Thank you. Mr. Radford, you have Jacobian Dorsey.
Yes, ma'am.
Dorsey.
Certificates for trial.
Did you do a rejection?
I think it's already been done, but you know.
Let me, I'll check real quick and see. Was there anything, hold on, you might not have to do one. Is there anything that's,
But he's already, I think I compact lawyers.
we're not going to call them that.
Okay, I'm sorry.
Mr. Coleman's notes look like he hasn't changed the offer or anything, Your Honor.
Looks like, the offer was 20
Yes, stacked.
to stack on top of a sentence he's doing now, correct?
Yes, ma'am.
All right, sir, you're Jacobian Dorsey.
Yes, ma'am.
And Mr. Dorsey, in cause number 25, DCCR 1896, you are charged with manslaughter. And we've gone over this before. Let me pull it up. Is there the indictment alleges second-degree felony offensive manslaughter, but looks like the state's filed a notice of intent to use prior conviction to enhance your punishment, which means we've gone over before. And when you sign that plea bargain rejection with Mr. Parker, that the state, you would be looking at a first-degree felony if you're found guilty for punishment purposes, which means the minimum punishment would be 5 years up to 99 years or life in prison. You understand that?
Yeah.
And the same offer is on the table now, which is a 20-year term in prison that would be stacked on top of a sentence that you're currently serving. Is that your understanding of what they've offered you? And you want to reject that and move forward with trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Radford will begin preparation for trial.
Excuse me, that that I'm actually doing time for right now already, that's on appeal.
Okay,
That's not a full conviction.
all right. Well, it'll all depend on when we get to the trial. I'll set it on the trial docket. If something gets affirmed by then the conviction would count. If not, then there's some legal issues that we'll take up at that time, which means it would be potentially just the 2 to 20, but we'll take that up at pre-trial.
Judge, it looks like a case has been brought over this week from something that happened in the jail. It may be a new harassment or assault on an officer. I think that's going before the grand jury tomorrow, if not tomorrow, next week. And I just asked that we put this on the trial docket. I don't think it's going to change.
No, yeah, we're going to go to put this one on the trial docket and then we'll deal with that one when it comes.
Thank you.
Thank you, Mr. Nichols. You can go back with the bailiff.
May I be excused?
Yes, sir.
Thank you. Yeah, I'll go back.
You too.
What do you learn? You gotta go into the following.
And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes,
Do you fully understand them?
yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
Objection?
it's admitted. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will also, as part of that plea agreement, sign the dismissal in cause number 25 DCCR 1211. I'm handing you the trial court certification. Shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Ronald Barrett.
Can you do?
Ronald Barrett.
Okay. I think go with that is what Tom's case. That's
Looks like Mr. Nichols is on that one.
We've got it covered.
Yeah, I've got it.
I'm just letting you know, I mean, y'all wasn't saying today.
Actually, it's my case.
Oh, it
They've been, most of it has been,
said Tommy.
no, it's no longer says.
Oh, on my reset, sorry.
You've been around this.
Right.
Sorry, case.
Good morning, sir. Are you Ronald Barrett Jr.?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Barrett, in cause number 26, DCCR 0890, you're charged with the state jail felony offense of unauthorized use of a vehicle,
Yes, ma'am.
and that's from January 28th of 2026.
Yes, ma'am.
The indictment alleges that you were previously convicted of unauthorized use of a motor vehicle August 3rd of 2009.
Yes, ma'am.
And after that was final, you were convicted of possession of a controlled substance March 22nd of 2011.
Yes, ma'am.
And then after that, convicted of unauthorized use of a vehicle April 14th of 2011.
Yes, ma'am.
And then again, unauthorized use of a motor vehicle June 26th of 2017. And then burglary of a building August 24th of 2022.
Yes, ma'am.
And how do you plead to that charge?
Yes.
And are all those prior convictions true?
Yes, ma'am.
I don't understand this agreement at all.
Judge, the vehicle in question is a scooter taken from a known address. The complainant that's well known.
And
Of me in the court.
I will also tell that there's been some cooperation with.
Okay.
Law.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And obviously you can tell that I don't like this agreement, but I understand there's some circumstances that Mr. Nichols and Mr. Parker have negotiated for that.
Yes, ma'am.
I want you to understand if you come back in here on another offense where you're stealing a car or getting into a building or stealing, I don't care if it's a scooter, I don't care if it's a Snicker bar,
Yes, ma'am.
you will not get an agreement like this again, regardless of what you've done. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Barrett's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Also that you entered those pleas of true freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find this prior offense is true. Sentence you in accordance with your agreement to a term of 2 years in the Texas Department of Criminal Justice.
Yes, ma'am.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you.
Yes, ma'am.
If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, ma'am.
Good luck to you, sir. You can go back with the
Thank
paper.
you.
All right, thank you. Sean Johnson,
It's rejection. He may be, this.
snowboarder. Isn't that his name?
Huh?
Yeah, the snowboarder.
Oh. I was thinking of the gymnast.
Oh, yeah. Perfect. Okay,
That's what I thought.
no, getting confused.
I'm going to Sean White.
Yeah.
Right. Sean Johnson is the gymnast. Probably not the same, definitely.
Yes, ma'am.
Good Good morning, sir. Are you Sean Joe Johnson?
Yes, ma'am.
And Mr. Johnson, in cause number 26 DCCR 0924, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from March 6th of 2026. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, July 8th of 2016. And then after that was final, you were again convicted of burglary of a habitation, a second-degree felony, February 15th of 2017. And what that means, sir, is that if you go to trial and you're found guilty, you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker, and I'm guessing you guys, it says months are checked off.
I'm sorry. I'm following up. Yeah.
So it shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 12-year term in prison. You have every right to reject that offer and have your case set for trial. Just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty. Do you understand all that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Mr. Parker has been appointed to represent you. He's one of the cases. He's one of the lawyers who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who could begin preparation for trial a little quicker. Is that okay with you?
I'm gonna do a attorney.
So I'm going to release Mr. Parker. We will appoint someone today, Mr. Johnson. They should begin preparation for trial very soon. Mr. Smith, is there any reason to believe or anything that you're waiting on that offer would be reduced with a different attorney? So I do want to make sure you understand that a different attorney is not going to necessarily get you a different deal, and that typically after today, I don't take those deals that you've already turned down. If something comes up that's different that your attorney doesn't know or the DA, then I'll consider it. But whoever that is will be out to see you very soon and begin preparation for trial.
Yeah.
All right, you can go back with the bailiff.
Yeah.
See, Miss Holmes, you got Stormy Folwell.
Ron, forward. Go through the motion, we can do an updated PSA.
I think you need to know exactly what you're gonna do on this one, though.
Yeah.
Oh, I do? Y'all do?
Mhm.
Well, how would you prejudge? Is it that clear?
She's very clear.
Oh.
This is it's one of those special drug things that the minimum is 10. But she pled.
Garrett, how's it going? Hey, I'm getting to get over it.
She's
Yes.
She's been to St. Pete twice.
Good morning. Are you Stormy Folwell? And will your client waive the formal reading of the motion?
Your Honor.
Ms. Folwell, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Ms. Folwell, in cause number 21-38655, I have a motion to revoke your community supervision. Shows that you were placed on probation January 26th of 2022 for possession with intent to deliver a controlled substance, a first-degree felony. And that was a 10-year term in prison that was probated for 10 years. Is that correct? The motion alleges that you violated your probation. It alleges in count 1 that you provided a urine sample January 26th of 2026 that tested positive for methamphetamine. Is that true or not true?
January 22nd.
January 22nd of 2026, excuse me. Is that true or not true?
Yes, sir.
True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
True.
Count 3 alleges that you failed to successfully complete the SafeP program and that you were unsuccessfully discharged from the supportive outpatient treatment on January 22nd of 2026 because you tested positive there for methamphetamine, amphetamine, and ecstasy. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening January 21st